Matina TV esu eni abusafo ye mo nyina akwaba ede eba ye channel ye so ensem bebre ena ekoso ewo eye social media no so se ne da ne bring na metransa meka se open wo #1 channel a ebema all the political stories, all the political updates, all the political news a efa oman Ghana won de eye Matina TV ena meka fo ede mo na ene ensem bia baba beto edwa ye de ebro ni nyina ene se His Excellency John Dramani Mahama after so baba ye president ewo man Ghana mu no ye nyina yi so okọ ye judicial service ho na enema bebre na ekoso ewo ho nom ama His Excellency ayes saye ewo ho Chief Justice Torkono ono kra no sese no His Excellency apamo no anase bukra no waje ne dwumadi as Chief Justice no de free ye mami ensem na eno yana ene anopai enkra ye nsaka a metimi aka se eye huhuhu kwesi broni beka se eye allege and said His Excellency John Dramani Mahama aye na adwen se yewra lawyer Tsikata bono ena oba be mana aye Chief Justice ewo oman Ghana mu amanioma akoyi edi ama oman Ghana if you say nim de ene nisuade hunu a wanya ewo lawyer dwumadie no ena afresu Ghana yama mra no mu no ade ewo so ye pa na papa no eba baba ya ebeboa eye pa. Now, after Sasanse we baby to Jano, ena ye raba ko a ono no ekoye da allege eye ensamono ekota TV3 edi mu nchire mu nyina eni hiye say Tsikata ebe baba ye Chief Justice ewo man Ghana mu nyina edi atu edwa abusha yenko na yentie yera no ensama okaye edi fa Tsikata a ono ye incoming Chief Justice no eho emra
of state, the Chief Justice should have been heard or given a hearing, made known of this existence of these petitions against her. Why exactly is that an issue?
Okay, so I think, like Martin Pebo rightly pointed out, our constitutional democracy is evolving, and by reason of that, I think we need to also look at where we were and why we are where we are today. Because if we don't get that clear, we are in problem and in serious trouble, sorry. You see, our constitution always mirrors our political history, in the sense that one of the accusations against Osajifo Dr. Kwame Nkrumah, rightly or wrongly, was the fact that if he disagreed with a court decision, particularly the Tawi Adamafio decisions, he proceeded to dismiss the judges. Whether he could do that or not. So by 79, when we're putting the 79 constitution together, we started bringing certain forward-looking provisions to safeguard the independence of the judiciary particularly. And so you will notice that in 79, after the man had won, and knowing the role that Chief Justice Apalu played relative to the commissions of inquiry involving Nkrumah's appointee, the view was that the pro-demand elements in Parliament felt that it was an opportune time to deal with Chief Justice Apalu with the creation of the Supreme Court. And therefore, if Chief Justice Apalu had gone through the parliamentary vetting process, would have lost it. And hence, the lecturer then in KNUST, Dr. Amakutufo, then brought to for an attorney general. That constitutional history has shaped what we have now in Article 146 to just provide a check with what has happened previously, so that going forward, we'll know what to do. Then came Frank Adjechum. If you recall, my senior Brighter Kuti had brought a petition for the removal of Chief Justice Apa. But strangely, that petition found expression in newspapers in terms of content, right? So President Kufuor had received the petition, but the petition was out there in the various newspapers, including the content. So what happened? Frank Adjechum then goes,
"No battery, please charge."
there's an in-camera provision. The word in-camera, the Latin phrase simply means in chambers. It allows a set
Low battery, please charge.
whole chain. It does not admit of any other thing. Well, the Supreme Court has departed one way or the other from
Low battery, please charge.
if the petition even comes out. Does it void the petition? One expression in newspapers in terms of content, right? So President Kufuor had received the petition, but the petition was out there in the various newspapers, including the content. So what happened? Frank Ajechum then goes to the Supreme Court. He said, no. There's an in-camera provision. The word in-camera, the Latin phrase simply means in chambers. It allows a certain level of privacy in the whole chain. It does not admit of any other thing. Well, the Supreme Court has departed one way or the other from the legal consequence if the petition even comes out. Does it void the petition? One becomes of the petition. Because in the case of Madame Charlotte Osei, we had gotten the benefit of seeing the entire petition. Even before the prima facie determination was made. But nonetheless, the process proceeded until she was removed. But you see, there's a curious development. What development is that? We are being told that the Chief Justice, as it were, has a right to be heard. Right? And like Marlene Senior pointed out, that is not borne out by the express provision of the Constitution.
Yes.
And so if you look in Frank Ajechum, the Supreme Court basically just said, such committees should find a way of bringing proceedings to regulate its activity. So in the specific case of Charlotte Osei, if you recall vividly, Madame Charlotte Osei, acting through her lawyers, had written to President Nana Addo Dankwa Akufo-Addo that, Mr. President, having gotten receipt of this petition for my removal, I need to have the benefit of knowing who and the nature of allegations being made against me. Fair point. Now listen to Mr. Eugene Ahin's response to Madame Charlotte Osei. He said, I find your response or request extremely curious. This is not the proper forum for you to be asking for copies of the petition against you. This is President Akufo-Addo, a lawyer. His executive human rights lawyer. His executive assistant, a lawyer. His deputy attorney general, now Godfrey Dame, a lawyer. Attorney General Gloria Kufu, a lawyer. All of them together informed the then presidential Gongon Bita, Mr. Eugene, that it was not in the place of Madame Charlotte Osei to be making a request for the petition at this level. And that, listen, when it gets to the Chief Justice, because remember that the process is bifurcated. There's one for Superior Court judges, and there's a separate provision when it comes to the Chief Justice. Because of the special role that she plays as the head of one co-equal arm of government. So the Constitution and its framers say, listen, when it comes to all those other persons, including the heads of independent constitutional bodies, what do? Let the Chief Justice be the one making the prima facie determination. In this case, that it involved the Chief Justice herself. She cannot be sitting on her own matter, making a determination whether the allegation against her meets a certain threshold called a prima facie. So what happens? He said, in that case, the president shall mandatory consult with the Council of State. Mandatory, no discretion. Yes. Question. Who then makes the prima facie determination? If you recall, in the specific case of Charlotte Osei, what we were told is that the president was just a conveyor belt, a conduit for transmission, without more. That is what we were told.
Yes.
What has changed? Incidentally, Godfrey Deboard, I'm a lawyer now, was a deputy attorney general then and supervised that process. You see, I have always maintained that because we are building a constitutional democracy that should last the next 200 years and beyond, we need to be very careful of the precedent that we set. When this issue of CJ came up, I reached out to some leading MPP lawyers, senior lawyers. I said, look, you all sat down for Akufo-Addo to destroy this country. You all sat down. And this, my friend, said, if Akufo-Addo did a wrong thing, why should Mahama follow? I said, what in God's name makes you think that Akufo-Addo deserves the right to be wrong, but Mahama cannot be wrong? What makes you guys think that for some reason you are better placed to do whatever pleases you and nobody can do the same? I think that our friends in the NPP must appreciate, and like I always use the word, and maybe you see, you are just asking yourself that there's no, you see, it is not only in the house of NPP that they are madmen.
But you see,
every house there can be a Mensa. Is that not the case?
Yes, exactly.
So you see, at that time, it was convenient to do everything because the entire NPP and Nana Danko Akufo-Addo, the Vice Dr. Mahmoud Bawumia, the Attorney General and the Deputy, the entire NPP spectrum were determined to get Charlotte Osei out. And so it didn't matter the question of fairness and reasonableness. And so we got to the point where the only time Mrs. Charlotte Osei got the benefit of getting a copy of the petition was when she appeared before the Justice Bene committee. And listen, it was Justice Bene, her ladyship Agnes Doji, and the late Justice Mafusa, Abrampa, and one other woman, 5. It was when she appeared that they formally gave her a copy. In fact, the first day, what they said was that they are coming to determine the rules to govern the committee and its work. That was then. What has changed? When Prez.Mahama received the 3 petitions, beyond forwarding it, has he taken any other action? No.
well, but if you look at Vincent Assefua's reliefs, and I go back there because this is one of 2 cases challenging what the president has done.
I was for way and Samoa a coso a year TV3 a yenua bemano edi munchechi mu and so edi ebrea yedin hunsemunano edi emo Martina TV. Mess also subscribe to your YouTube channel and Facebook like video edi amami share my for nye bihwe na fe for commenting so bra e wo comment section yakram.